بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيد المرسلين وعلى آله وأصحابه أجمعين أما بعد. Inheritance in Islamic law. We're going to divide this book into 10 lectures. Possibly we might cover one or two in one class, but you can say that this book is divided into 10 chapters. The first chapter is about the verses of inheritance. So, what are the verses mentioned in the Quran about inheritance? What are their meanings? Right? And then there are some frequently asked questions about inheritance in general. So, we're going to talk about those inheritance questions as well. So, as far as the verses of inheritance are concerned, there are different. There are only a few things in which Allah subhanahu wa ta'ala himself has delved into the details of. The rest, he mentions them in principles and absolute statements which have been then further explained to us by the Prophet ﷺ. And amongst those things which Allah Himself has taken the liberty of mentioning in full detail are the ahkam of mirath. So the ahkam of inheritance are things that Allah subhanahu wa ta'ala Himself has taken the liberty to mention in full detail. Because frankly, al-ilmu nisban. You can divide ilm into two parts. Ilm al-ahya wa ilm al-amwat. There's the ilm for the living, the ilm that you require when you are living, and the ilm for the dead. And mirath is basically half of ilm because it's the ilm of the dead. What happens to a person after they die. So this first verse in front of you is from Surah An-Nisa, verse number 7. Allah subhanahu wa ta'ala mentions, أعوذ بالله من الشيطان الرجيم للرجال نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون مما قل منه أو كثر نصيبا مفروضا. That from men is a share from whatever their parents and relatives leave behind, and for women there is a share from whatever their parents or relatives leave behind, whether it's few or whether it's more, whether what they left behind is less or whether what they left behind is a lot. Nasiban mafruza, and the share that these men and women have is fixed by Allah subhanahu wa ta'ala. So this is a very small ayah which mentions that Allah subhanahu wa ta'ala has fixed the shares of miras that men and women are supposed to receive. And then Surah An-Nisa itself explains in full detail the verses which mention about the inheritance. So first you have Surah An-Nisa, verse number 12. Actually, verse number 11 and 12. They both go together. So verse number 11, يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين فإن كن نساء فوق اثنتين فلهن ثلث ما ترك إلى آخر الآية. Now, obviously, the full detail we'll discuss it later on, but just focus on the blue parts of the ayah. Those are some of the things that we need to explain. The full details will come later on when we discuss about the shares of the people who are supposed to receive them. So in this verse number 11 of Surah An-Nisa, Allah subhanahu wa ta'ala mentions لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ, that for men, the share is twice as that of the women. And this goes for brothers and sisters and sons and daughters. So if siblings or if children of both gender are present, then للذكر مثل حظ الأنثيين, that's the principle that the male counterpart will receive twice as that of the female counterpart. So that's one thing that we need to know. The second is من بعد وصية يوصى بها أو دين. That's the second part which you need to consider. It mentions that this division of mirath, of inheritance, happens after two things. If a bequest has been made by the deceased, also if there is some debt that the deceased has to pay. After you are done with these two things, after completing his or her bequest or paying up his or her debts, that is when the miras is distributed amongst the waratha, amongst the heirs of the deceased. Now, the important thing to notice is that Allah subhanahu wa ta'ala first mentions wasiyah, He first mentions bequest, and then ba'di wasiyatin yusa biha. And then He mentions they, which are debts. Although the ulama are unanimous on that the debts will be paid first, and if something is left behind, then the bequest will be fulfilled. But over here, Allah subhanahu wa ta'ala is mentioning bequests before the debt. He's mentioning wasiyah before the dain. Although the ulama say that the dain comes before the wasiyah. So what is the wisdom behind actually giving wasiyah preference in the ayah over the debt or over the dain? The reason behind is that the dain, the debt that a person has, obviously it has people involved, which will come and ask for whatever they were owed by the deceased. Like if someone owed me $1 million and they passed away, I'd probably go to their family asking to get my money back, right? So they have someone in place in debts. People are in place where they will come to ask for what is rightfully theirs. But that's not the case in Wasiyah. It was simply a request by the dying person. It was just a request. There isn't anyone who's going to ask for it. There isn't anyone present who will be demanding it. And so this Wasiyah part, this bequest, is basically dependent on the enforcement of the Waratha themselves. If they choose not to, if they want to hide it, there's no one who can force it out of them. There's no one going to be there to demand it from them. And so, in order to create ta'qeed, in order to create emphasis on the fact that you have to fulfill the bequests of the deceased as well, Allah subhanahu wa ta'ala mentioned the part of wasiyah before the part of dayn. Basically, he's emphasizing the fact that the bequests have to be fulfilled as well. You should not go to the stage of distributing the irth before the person's bequests have also been met. So this is what this part of the ayah is trying to tell us. Then he mentions آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا. Your parents or your offsprings, you don't know which of them will benefit you more. This is basically the wisdom of Allah subhanahu wa ta'ala behind taking the responsibility of dividing the shares of mirath himself. What's basically said to us is that if we left the decision of mirath onto human beings themselves, if we gave them full right and full autonomy to do whatever they want, they might make decisions based on their general feelings or whatever the state they're in at the moment, right? And human beings, they're very dynamic. Their emotions are dynamic. Their thoughts are dynamic. They're always changing. So we're prone to making irrational, biased decisions. We don't know who's going to benefit us more in life. You don't know if the children that you're going to have will be of any use to you. They might turn out rebels. They might reject you altogether. You don't know if your parents are the one who are going to be more useful to you. They might abandon you in some point in time. So nobody knows what is going to be their final destiny in terms of their relations with their siblings, with their parents, with their other relatives. It can change. One day you can have a very bad day, you can have a bad relation with someone, and a few years later you might become best friends with them, right? And so because of the dynamic situation of this continuous change, if this decision was left to humans alone, they would make very bad decisions. And so Allah subhanahu wa ta'ala himself took the responsibility of discussing who will receive what when it comes to inheritance. Now, obviously, when we go into detail, you'll see in some cases it's possible that Allah subhanahu wa ta'ala is assigning more share to the son than the daughter, yet the daughter becomes more useful to that dying person in life and even after in death, right? So obviously in this case, the hikmah that Allah is explaining behind this distribution, that you don't know who's more beneficial. Yet the share that Allah has devised for the son and the daughter doesn't seem to be more beneficial in terms of the deceased. But obviously when laws are made, they're supposed to be made in general, right? Allah subhanahu wa ta'ala could not, he could have, but it wouldn't have suited us to mention each and every person coming to this earth and how their miras should be divided on who's going to be more anfa or more beneficial to that person, right? So laws are made on generally, but once they're made, even though may not suit some situations, but they're still employed. And so even though in some cases you might see the one receiving more is less beneficial to the dying person or to the deceased person, yet still we have to follow the general law. So that's the third thing that we need to understand about this ayah. That even though, first thing, that we're dynamic, our decisions are biased and influenced a lot by our emotions. And the second, that laws are made for general situations, even if there are exceptions, they won't affect the general law. Now let's look at the third ayah. The details will come later on. Just look at the second last line in which Allah subhanahu wa ta'ala he mentions وَإِنْ كَانَ رَجُلٌ يُورَثُ كَلَالَةً أَوْ امْرَأَةٌ. If a man or a woman, uh, they're being inherited from, they're the testators, and they're kalala, then this and this will be how the mirath is going to be divided. The question over here is, what does this word kalala mean? That's what we need to understand. So the word kalalatun actually refers to a person who dies and he leaves behind neither a parent nor a child. La asla lahu wa la fara'. They don't have parents or children, right? So kal literally means azaf. It means weakness. So when you don't have your roots and you don't have any branches, a tree without a root and without branches is a very weak tree, right? And so this rajul or this person is a very weak person for the fact they don't have any roots, their parents are gone, they don't have children to forward their own legacies. So such a person is called a kalala, man or woman, if they die without any children or without any parents. So we need to understand this word, kalala. And the last part is min ba'di wasiyatin yusa biha aw dayn ghayra mudar. We already looked at this part, min ba'di wasiyatin yusa biha aw dayn, in verse number 11. But in verse number 12, Allah subhanahu wa ta'ala actually adds another word to the sentence. He mentions the word غَيْرَ مُضَارٍ, right? This is basically to tell that the wasiyah that a person is supposed to make. Similarly, a dain, a debt which is supposed to harm the inheritors, uh, it won't be enforced. So what is al-muzarratu bil wasiyah? So what is damaging and detrimental in terms of wasiyah, in terms of bequest? That is to make a bequest of more than one third. So as you know, you can only make a bequest to one third of your entire wealth. Anything more than that is rendered invalid because making a bequest more than that is harming your waratha. It's harming those who will inherit from you. So the wasiyah that should be done should be غير مضار, should not harm the inheritors. أو دين غير مضار. What does that mean? What is al-muzarratu fi dayn? What is detrimental in terms of debt? That is for the dying person to make, to claim that he owes someone who actually he doesn't owe anything. So, for example, if someone gets in a fight with his inheritors, if it is children and his family before dying, and then he claims that I actually owe my entire wealth, or let's say he only had $6,000, and he says that I owe 5,000 or $6,000 to person XYZ. Although he never owed him anything, but he's only making this claim. He's only saying this in order to harm his waratha, in order to harm his heirs. So this kind of dain or this kind of iqrar bil dain is unacceptable. So whether it's a bequest from the deceased or the dying person, or whether it's a claim of a debt that he owes, that is muqayyad, and that is should be غير مضار. It should not be with the intention of harming the waratha. If it is, then both this wasiyah and this dain will be unacceptable. So these were the important lessons that we need to keep in mind from these verses. The details will come later on, inshallah, but these parts that I've mentioned to you should be at the top of your head at all times. Now let's talk about some frequently asked questions about mirath. And the first one is a very famous question that has been raised by the West a lot, is that why is it that daughters and sisters get only half of the sons and brothers, right? I mean, they give this, so why is it that women are getting half of men, even though living in a Muslim country, for example, let's take this example, they might be in a weaker financial state because they probably don't earn. So obviously, everybody has their own expenses, so they need more wealth in order to meet those expenses, right? Or you could go to the West and they'd say that there's a difference in the payroll between both genders. So why is it that daughters, even though they may be working, they get less than if their brothers were to work? So why is it that the women are getting half of the men? So there are a lot of reasons. There's a lot of wisdoms why there's a difference between the shares of the both. So like first of all, women in Islam, makfiyatul mu'na wal haja. I mean, all their needs are sufficed. I mean, they're met by someone else. They don't need to trouble themselves with it. So either her nafaqah, her expenses are being met by her grown-up son or father or brother, husband, or any other relatives, her uncles, in some cases, or even her cousins, right? Second of all, a woman in Islam, they aren't required to spend on anyone. They don't have financial responsibilities towards others, right? Unlike men, whatever they own is their own. Uh, there isn't any responsibility on them to actually spend on others. Third of all, expenses of men are usually more than that of the women for the simple reason that he has to bear the costs and maintenance of other people as well, of his mother, his wife, children, other relatives who may be unable to earn, for example, because of sickness or disease, injury, or maybe some other woman in the family, like an aunt who can't earn or spend because she doesn't have any children, etc., etc., etc. Fourth, the husband is supposed to give the wife mahar. He's also basically tasked with providing the sukna, the ta'am. So he has to give the maintenance, living space, clothes, food, everything else. Fifth of all, educational expenses for his children, the maintenance of his children, all the expenses, the medical bills, all of these things, they're all the responsibility of the husband, not of the wife, of the father, not of the mother. And so, because of all of these responsibilities that a man has, it seems only fair that in some place Allah subhanahu wa ta'ala would favor him with something extra that he may be not giving the female counterpart. And this is actually a very logical uh, concept which is applied, I guess, everywhere in the world. That the more responsibilities that a person has, the greater the rights they also get. I mean, basically, rights are tied with responsibilities. If someone is at the top stage of the hierarchy, they enjoy a lot of rights, but they also have the most responsibility. Whether it's in a household, whether it's in an institution, whether it's a country. I mean, depending on your political system, the president or prime minister, they get the most rights because they have the most responsibilities. I mean, in the religious system, the Prophet ﷺ and the Prophet's messengers, they had the most rights because they had the most responsibilities. In an institution, the CEO has the most rights because he has the most responsibilities. So wherever you go, this is logic applied everywhere in the world, that the more your responsibilities is only fair, the more rights you get. And so that's why, because men in Islam, in terms of spending, since they have all of the responsibility, or most of the responsibility in 90% of the cases, it's only fair that they receive more than women in this regard. Like, let's take an example to really understand the hikmah of this tashri. What's the wisdom behind this law? So let's say a person dies and they leave behind a son and a daughter. Fakat. They don't leave behind anyone else, right? So no parents, no wife, just a son and a daughter. So obviously, let's assume that he leaves behind $3,000. So obviously, لِلذَّكَرِ مِثْلُ حَظِّ الْأُنثَيَيْنِ. Men get twice as that of the women. So the son will get $2,000 and the daughter is going to get $1,000, right? Now let's say they're both about to get married, and if the son he wants to marry, obviously he's going to give the mahar to his wife. Supposedly, let's say that it was $2,000 itself. Now, everything that he inherited, he basically just gave in the mahar, right? And other than that, still has to provide a place to live, provide for her clothes and for her food as well. Now, supposedly, the daughter is also about to get married. Not only that she keeps that 1,000 she got in inheritance, now she's being married to someone, and let's say her mahar was $2,000. She received 2,000 more, and now she has $3,000 without any responsibilities. So the end result you can see is that the daughter is more well off financially than the son is. Uh, Although this is a very simple example, but it shows with the wisdom behind this division that Allah subhanahu wa ta'ala has actually done. So the question remains, who do you think is better off, and who do you think is left with more wealth after all of this is done? So this is the basic wisdom behind why للذكر مثل حظ الأنثيين. Second question that's also posed is that, has Islam oppressed women in inheritance? This is basically stems off the first question, is when they see this differentiation, and in other cases as well, they say the question rises, did Islam oppress women in inheritance? Let's go back in a history. Take both the Arab history and take the European history. In Arab history, women were treated as mal themselves. I mean, forget rights. They had this qanun that which basically said that whoever doesn't fight for the tribe, who cannot fight for the tribe, should not be receiving any wealth at all either. And so women and children basically in Arab did not receive anything, simply because they could not defend the tribe against invaders and against the opposite tribes. So she used to receive nothing. And the same can be said about Europe before industrialization, and even after industrialization, before modernism. Women were not in any good state in Europe as well. They were treated similarly as beings of lesser existence than men. And although she might have been a single daughter to a family, she might receive something. In most cases, where there be more families, she might receive nothing at all. So in both cases, in the Arab and in Europe, women used to be in the background, having no rights whatsoever. It was only when Islam came that their shares were fixed in a text, in a legal text, in a holy book, which no one can change to the end of times. It was the first time that she was given something. Then you have the fact that she isn't given any responsibilities at all in terms of financing other people or even herself in this regards. And she's also given the right to earn if she wants to. But now there's some people, those people arguing for equality between men and women. They suggest that Islam has actually oppressed women in inheritance by giving her only half of what men receive. And they turn a blind eye to the oppression that they have been causing. They forced women out of their homes to work in factories, to work in fields, to work at other people's places. They forced her to serve other people, and they think that they've done everything. They took the rights that she had of being spent on having her needs met by the men in her family, forcing her to fend for her own, and the audacity they have to say that Islam is the one who's oppressing women. So you can see the irony of that. So they cry for equality, they cry for women's rights, and they're the ones who've actually uh, made her life more difficult, made it more suffocating. So when your human logic is going against the wisdom of Allah subhanahu wa ta'ala, you'll see all these funny anecdotes that people, all these funny scenes that occur because of the things that people are trying to do. Now, why were these verses revealed? That's the third question that happens. Basing on what I just told you, that women weren't considered to receive anything, there was a need for these verses to be revealed. And usually this has some historical context to it. So, for example, in the Sahihain al-Bukhari wal-Muslim, it's mentioned that the wife of Sa'd ibn Rabi' radiallahu anhu, who had actually died, she came to the Prophet of Islam and said that Sa'd had two daughters, uh, and their father Sa'd, he was martyred at Uhud. He fought with you and he got martyred. Now, Saad's brother, I mean the daughter's uncle, he took all of the mal, he took all of Saad's wealth and hasn't left for my daughters anything. And I cannot have my daughters married without wealth. I need it to actually marry them off. And so the Prophet of Islam, he said nothing. He only mentioned, يَقْزِي اللَّهُ فِي ذَلِكَ. Allah will make a decision. And that's when the verses of the Quran, يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ were revealed. And so the Prophet Islam sent a message to their uncle saying that give the daughters of Saad two-thirds of his wealth and give their mother, the wife of Saad, 1/8 of the wealth. And whatever is left afterwards, that's all yours. There's another historical context to these verses as well. Abdul Rahman ibn Thabit, the brother of the poet of Rasulullah sallallahu alaihi wasallam, Hassan ibn Thabit. When he died, he only left behind his wife, Qahha, and he also left five daughters. But what happened is that the male waratha, they took all the mal. So the Qahha, radiallahu anha, she went to the Prophet Islam explaining her situation, and that's when the verses of these of inheritance were revealed. So the basic reason why they were revealed is that the Arab at the time were depriving the women of their rightful share in inheritance. And that's why Allah subhanahu wa ta'ala, in order to cut off this problem, He revealed in full detail the verses of the earth. The next question that you might have is, I live in a non-Muslim country, so how should I deal with matters of inheritance? So obviously the law is different there than it would be in a Muslim country. In most Muslim countries, in Arab and in subcontinent, it's in law that according to Sharia, the miras will be divided when a person is deceased. That's automatic. But in Western law, it's either it's totally dependent on a person's will, their bequest. They can do whatever they want with their wealth in their bequest. Or if no bequest has been made, there isn't a will, then it's divided equally amongst the waratha, or they have some other arbitrary qanun in which they use in order to decide who gets what. But I, as a practicing Muslim, what I can do to make sure that when I pass away, my inheritance is distributed according to Sharia is basically make a bequest. Know who will be the people who will inherit from me after I pass away. And then in my will, write exactly the share that the Sharia would have given them and make it legal. So after I'm gone, when the will is being read and being carried out, the mirath will be divided according to what the Sharia has prescribed, right? But obviously, we know that making a will is not an obligation. This is the best thing that a person could do in order to make sure that in order to make sure that their mirath is being divided according to the laws of the Quran. But if they fail to make a will and it goes to the government and they decide on how to divide it, uh, inshallah, a person won't be held accountable for that because it's not something that a wajib that they left out. It was the situation which occurred. But in order to come close, in order to reconcile, in order to make sure we follow the best we can, what a person can do is make a will based on the implications of the Islamic legal system. Now we'll talk about the system of inheritance in Islam. This is the second chapter. We'll talk about irth, what it means, and what is its legal definition. Then we'll talk about the rights related to a person's legacy, the stages of heirs and how they inherit, the types of inheritance, the warrants of inheritance and the components of inheritance. We'll talk about conditions, the impediments to inheritance, the difference between hidden and deprived, and a general list of the male and female heirs of any single person. Now we know that the Sharia has a whole system of inheritance based on a very calculated monetary system. The ahkam of it are they're muhkam, I mean, which they're in the sense perfect that there's never any khulf. They're very specified, and like you already know that Allah subhanahu wa ta'ala has given both men and women the right to own if done so by legal means, right? Similarly, Islam has allowed for the transmission of whatever one person owns in their life to his own waratha after he's passed away. So, like I've said again and again, that Allah subhanahu wa ta'ala himself took the responsibility of explaining all the ahkam of mirath in complete detail. There are only just a few places where we know some of the ahkam of mirath from the Sunnah. Uh, Maybe in some cases ijma, but as you know, ijma is based on the Quran or Sunnah. And there's no qiyas. There's no qiyas involved in inheritance whatsoever. And it's not just inheritance. Remember, whenever there are numbers involved, you cannot use qiyas. So in zakat, there is no qiyas of how much you need to owe before you give zakat. There's no qiyas. In mirath, there is no qiyas. Similarly, in taqadir, wherever there are numbers involved, there will be no qiyas involved. All because the number of prayers, how many units in one prayer, all of these things must be decided by Allah subhanahu wa ta'ala. Or in some cases, the Prophet alayhi salam. Because each time the same question could arise, why 4 units of Zohar, why not 5, or why not 6? The same could go, why 2.5% of the entire wealth, why not 1% or 5%? So whatever number you choose by using your own logic will be arbitrary. You cannot defend it specifically. So that's why whenever there are numbers involved, uh, remember there cannot be any qiyas involved. You need to have some legal text supporting you. Anyhow, so irth is one of those things which can be used to own mal. So what is irth and what is legacy? Linguistically, irth means the transfer of something from one entity to another. So this transfer of something, that something could be wealth, that something could be status, that could be knowledge, could be anything, transfer of anything from one person to another, whether they're family or they're complete strangers. So like in the famous hadith, al-ulama'u warathatul anbiya, that the ulama, the scholars, they inherit from the anbiya, from the prophets. And what is it that they inherit? وَإِنَّمَا لَمْ يُوَرَّثُوا دِينَارًا وَلَا دِرْهَمْ وَلَكِنَّهُمْ وَرَّثُوا الْعِلْمَ. They don't get dirham and dinar. They don't get money. What they get is ilm. So you see in this hadith, you know that waratha can be from outside your relatives, and you also know that irth can be anything, wealth or otherwise. But this is its linguistic meaning. But when we talk about the legal definition of irth, of mirath, or inheritance, that is a transfer of ownership from the deceased to his or her living heirs, be it land, wealth, or legal right. So things like status, things like ilm, these things aren't part of the legal definition. Similarly, it's the transfer of ownership from the deceased to their living heirs. So it's not anybody, it must be one of the people who actually inherit one of their heirs. And one condition is that it should be their living heirs. If they're already passed away before this person, then they receive nothing. Then you have legacy. So the definition of legacy, or what we call in Arabic taraka, is whatever wealth, rights, and debts the deceased leaves behind. So whatever I used to own in the material sense is my legacy. Now, what are the rights related to a person's legacy? I mean, the wealth. So supposedly I pass away. So what are the things that are to be done in the legacy that I leave behind, in the wealth that I leave behind? So the first thing are funeral and burial expenses without extravagance. So the cost of bathing the deceased, the cost of shrouding him, and the cost of burying him. Done in moderation, this will be taken from whatever wealth the deceased leaves behind. So that's the first thing that must be done. After you're done with this, the second thing you have to do is repay human debts. So if I owed anyone anything in my lifetime, then from the wealth that I leave behind, that is going to be met first. I have to, or my waratha will have to repay the debts of any human being who I had interaction with in this lifetime. Now, I've included the word human debts specifically because we're talking about Hanafi fiqh, right? And so Hanafi fiqh, you only pay human debts. The debts which are between a person and Allah subhanahu wa ta'ala are not the responsibility of the waratha to pay. So for example, if a person had to pay zakat, but they didn't, the waratha won't be forced to give the zakat from the deceased's wealth. Or if, let's say, I made another that I was going to give this and this wealth in the way of Allah subhanahu wa ta'ala, or maybe I had to give the kafara, right? All these things are debts, but that they're between Allah subhanahu wa ta'ala and a person, not between two human beings. So repaying such debts, which are between Allah subhanahu wa ta'ala and the deceased, they are necessary according to the Aimma Thalatha, according to Imam Malik, Imam Shafi, or Imam Ahmad ibn Hanbal. But as far as Hanafi are concerned, unless the deceased makes a bequest, those debts between Allah subhanahu wa ta'ala and the deceased are not obligatory on the waratha to pay. But human debts are. So that's the second thing we do. Repay all the human debts of the deceased. The third thing is the enforcement of bequest from the one-third of remaining wealth. So after you're done with the funeral, after you're done repaying the debts, if anything is left behind and the deceased made a bequest, so from one third of it, the bequest shall be met. The fourth thing that happens is the division of inheritance as per Islamic law. So now everything, when you go through the first three things, if something is left, then it will be divided as per the inheritance. So you need to go over the first three steps before the inheritance is divided and accordingly. Now let's talk about the stages of heirs. There are different types of heirs. Those who will, the waratha, those who will be receiving, and each of them has its own way. Number one are the entitled. These are basically those people whose shares have been allotted in the Quran. The second are the residuary. These are those people who receive the entire wealth of a deceased if there are no entitled, or whatever is left behind after giving the entitled people. The details will come later on. Entitled are also known as Zawil Furuz, those whose share has been mentioned in the Quran. The residuary are known as the Asaba, and I'm sure you've heard this word a lot of times before when talking about the awliya, ala tartib al-asaba. So now you'll know what the asaba actually means. The third is return to the entitled except spouse. The third stage, what happens is that if, let's say, you don't have any residue, after giving the entitled people their shares, some of the mal is left, or the wealth is left. What you do is then you redivide it against the remaining, the waratha. Again, you give it to the entitled people, except for the spouse. The husband or the wife doesn't get any part of the miras the second time. The fourth are known as distant kindred. They're other relatives of the person who are not the asaba, and they only receive something. The distant kindred only become heirs if you neither have entitled people nor any residuaries. The fifth is return to spouse. I mean, if you don't have even distant kindreds, you just only have your spouse. So the husband only has his wife, no other children, parents, relatives. The wife only has her husband, no children, relatives. Then after giving whatever they receive from being entitled from the shares that are mentioned in the Quran, they receive the rest of the wealth as well because there isn't any other person who's going to receive it. And let's say they even don't have a spouse. So if, or maybe, yeah, so they don't have a spouse and they made bequests over one third, right? So obviously, if you have no one who's going to inherit from you, no one at all, then any bequest that you made, even if it's more than one third of your wealth, will be fulfilled because that wealth has to go to somewhere. And if none of the six are present at the moment, it'll basically go to the public treasury, the Baytul Mal, or the government, whatever the situation is. So these are the shares, or these are the stages of heirs in a descending order from top to bottom in who will be the first one to receive something. It talks about types of inheritance. So first of all is irth from entanglement, which we mentioned being Zawil Furuz. You can either get mirath from having a share specified for you in the Quran, or if from residue, if from the taqsib, you can get miras from being a asaba, irth birrad, or you can get irth from repetition, means after being given what you got and there's still mal with the deceased, you get that once again. And the fourth is irth birrahim, that you get a mirath, a share in it, because of your relation with the deceased. And what are the asbab or the warrants of inheritance? Like what warrants that you will receive inheritance? So number one is al-qaraba al-haqiqiyya. That's basically blood relations that we would have. The second is marriage, and the third is non-blood relations. Uh, Non-blood relations or wila, in our times it doesn't exist. It basically used to mean that if someone freed a slave, man or woman, if none of the heirs were present, like that man or woman who freed a slave had no heirs at all, no blood relations, no marriage, no nothing, then their wealth would go to their freed slave, their mawla. So al-wila, or these non-blood relations, can also be a warrant for receiving mirath. The components of inheritance are three things. First of all, you need a muwarrith, a testator, a person dying, leaving behind a legacy. The second, you have a warith, that is a heir, the person who has the right to inheritance, because any of those warrants that are just passed behind. So they're heir either because of their blood relations, either because of being a spouse, or maybe because of some non-blood relation. And the third thing you have is al-mawruth, the legacy, the thing that the testator is leaving behind, whether it's land or any other material wealth. So this legacy is called irth, mirath, taraka, turath. It has different names. All of them mean the same thing. Anything that the deceased leaves behind, the testator leaves behind for the waratha. The conditions of irth. What are the shurut al-irth? Obviously, the first is the death of the testator. The murith has to die before his wealth can be given off, either actually or deemed dead. So actual death, he just passed away, and is deemed dead is when a person migrates to an enemy country, a darul harb, a non-Muslim country with which you have war type relations, or at the minimum you don't have any peace treaty with them. Any non-Muslim country you don't have peace treaty with is considered as darul harb. If a person migrates there, then the qazi can rule them as dead, because you never know with such a state when you're going to war. And when you go to war, you go to war against all the people there, Muslim, non-Muslim alike. So they'll be deemed dead by a Muslim qazi in the Muslim state, and then their waratha will receive whatever they are supposed to. The second condition is the confirmation of an heir's life at the testator's death. At the time that the murith is dying, the life of their waratha should be proven. So if a father is dying, it should be made sure that at the time of the death of the father, the son, the daughter, the wife were alive. If you cannot confirm that the wife was alive at the time of the father's death, she doesn't get it because you need to be alive at the time the testator is dying. So your life should be confirmed. The heir's life should be confirmed at the time of the death of the testator. If it's not confirmed, that they don't get the mirath, because if you're not alive, you don't get any mirath. Until that's confirmed, you're not part of uh, the waratha. And the third is the knowledge of warrant. You should know what is warranting this inheritance. Is that person getting the inheritance based on having blood relations? Are they getting it based on being their spouse or some non-blood relations? Knowing this is necessary to be able to determine in which class of heirs is this person included. Is he from the Ashab al-Furuz? Does he have a fixed share in the Quran? Is he from the Asaba? Is he from the Dhabil Arham? You need to know that. So you need to know what is warranting the inheritance of this person. So knowledge of the warrant is also necessary. So you need to make sure that these three conditions are met before you can go ahead to distribute the mirath. Now let's talk about the impediments to mirath. These are the things that deprive a person from inheriting. So if any of the four are present, then a person cannot inherit effectively from his motive. The first is servitude. So being a slave deprives a person from receiving inheritance. So supposedly my son or my daughter were to be a slave, then when I die, they would not receive any mirath. Why? Because you should know that slaves didn't have the right to ownership. Whatever they owned is actually owned by their master, by their Mawla. And now if my daughter or my son who were a slave were to inherit from me, that wealth would automatically go to their master. And if their master is not related to me, he's not supposed to get my mirath. And so that's why servitude acts as an impediment of inheritance, of it's a mani'ul mirath. The second is homicide. So if a person deliberately, intentionally kills his motive, then they do not receive inheritance. So if a son, he actually kills his own father deliberately so that he can receive the mirath, then this homicide acts as an impediment and that person cannot receive the inheritance of his father anymore. This is another mani al-irth. Uh, the legal maxim behind this is man istajala shay qabla awanihi uqiba bihirmanihi. Whoever hastens to get something before its time is due is punished by being deprived of it. So for example, if you pray Asr before the time of Asr actually starts, your Asr is unacceptable. You don't get the ajr of it. It's futile, right? So similarly, for example, if someone wants children, the time for children is after marriage. You cannot do zina to get children. So if someone goes ahead to does that, the nasab is not going to be proven it. I mean, they're not going to be considered as your children. You won't get the right to them. So similarly over here, homicide being done in order to speed up the process of receiving the mirath, the person will be deprived of it altogether. The third is difference in religion. تباين الدينين or اختلاف الدينين. اختلاف الدين. Remember, when we say اختلاف الدين, we basically mean Islam and every other. So Christians and Jews, although they're different religions, but they're grouped as one. So Christianity, Buddhism, Judaism, Hinduism, whatever religion there is, it's grouped as one and Islam as the other. So Ikhtilafuddin basically means Islam and Kufr. So a kafir cannot inherit from a Muslim, neither a Muslim can inherit from a kafir. A hadith mentioned in both Bukhari and Muslim, the Prophet Islam, he mentioned this, لا يرث المسلم الكافر والكافر المسلم, that a Muslim will not inherit from the disbeliever and the disbeliever will not inherit from the Muslim. And all four of the Aimma, Imam Abu Hanifa, Imam Malik, Imam Shafi, Imam Ahmad bin Hanbal, they agree. There are some ulama who say that al-Muslim yarithu al-kafir dun al-aqs, that a Muslim can inherit from a non-believer, but the non-believer cannot inherit from a Muslim. Uh, and basically, their argument is that al-Islamu ya'lu wa la yu'ala alayh. I mean, Islam gets preference, other things, so it has special benefits that other religions don't, and this is one of the benefits. But obviously, once you have a hadith, which is basically telling you that none of them can inherit from each other, this argument is irrelevant. Hanafiya, for example, they don't include apostasy from one of the impediments of inheritance. So like the Aimma Salasa, Malikiya, Shafiya, and Hanabila, they say La yarithul Muslim il murtad. A Muslim cannot inherit from an apostate, just as he cannot inherit from another kafir, a non-believer, simply because of the apostasy, that person just exited the folds of Islam and became a non-believer. So whatever wealth they have, even if they're living in a Muslim country, uh, is ghanima, or it's for the state. So you cannot inherit that. But according to Hanafiya, malul murtad yakunu mirathan liwarathil muslimin, that an apostate's wealth can become mirath for his male heirs for his Muslim heirs as well. And this opinion of the Hanafiya is the same opinion as that of Abu Bakr, Ali, wa Ibn Mas'ud radiyallahu anhu. And I guess because there is no concept of a Baytul Mal these days, this opinion is in fact more valid. I mean, it has more merits to it. So these four are the impediments or the mawani or the mirath, things that stop you from receiving mirath. Such a person, an impeded person, or what we know in Arabic as mamnu or mahrum, is considered non-existent, is as if this person never existed. So the son who killed his father is as if he was never born. Or the daughter who is a slave is as if she was never born, right? The wife that is of another religion is as if she was never married to the person. So an impeded person is basically considered non-existent, non-effective. But what this means is that, as we'll see when we come to the details of the entitled people, in some cases, when a person is present, they affect the shares of another person. It's very much possible that person A may not get anything themselves, but they will change another person's inheritance. For example, if a person has two siblings, then the mother gets 1/6. If they have no siblings, then the mother of that dying person or the dead person gets 1/3, right? So the presence of two siblings basically shifts the mother's share from 1/3 to 1/6. Now, if that person also had a son present, his son was also alive, the siblings don't get anything. They're mahjub, they're hidden. They don't get any shares. Yet they still affect the mother in terms of changing her mirath from 1/3 to 1/6. If the son was not present, the siblings would also get a total of 1/6. Or in some cases, they would be the asaba. They'd be receiving something and then they'd be changing the mother's mirath as well. But in the case the son is present, they still change the mother's mirath, but they themselves don't receive anything. So unlike the impeded person, a hidden person is not considered as non-existence. They're not non-effective. They do affect the share of other people. And these hidden people are known as mahjub. So there is a difference between being mahrum and being mahjub. A mahrum is an impeded person who has one of these four impediments with them. A mahjub person is that they don't get mirath or they get less mirath simply because they're next in line. There is someone above them in stage who is entitled to mirath, but even though they don't get anything, they can still affect the shares of other people. All those details will come later on. Now, there's one impediment that I haven't discussed, that is the difference of boundary. Some people say that's a difference in country. I'll elaborate this in a later class because there are things that you need to understand about countries and boundaries before we can actually delve into these details. So it doesn't concern us at the moment. So at the moment, just keep these three things in mind. Servitude, homicide, and difference of religion. They're impediments, and a person impeded is basically no longer exists, and so they don't affect anyone whatsoever. But a hidden heir is a person who doesn't get something, but they can still change another person's share altogether. Last thing we discussed today is a general list of the heirs in both men and in women. So who are the possible heirs from men? Could be a person's son, their grandson, and so on. And remember, when we talk about grandchildren in Mirath, we mean the son's children, the grandchildren from the son's side. The grandchildren from the daughter's side, they're not part of the Zabil Furuz, or the person or the people initially entitled to Mirath. The third is the father. The fourth are paternal grandfathers, as high as they go. The fifth are brothers, whether they're full brother, sharing both parents, or half brother, sharing one parent, either the mother or the father. Sixth is nephew, whether it's a nephew, whether it's the son of a full brother, or a son of an agnate brother. Now understand two terms. When we talk about siblings, not even just siblings, whether uncles, whether cousins, you have full and half, right? In English, or in Arabic, there's a difference between half brother or half sister from a mother's side and half brother sister from daughter's side, from father's side. In Arabic, the term for a full relation is a shaqiq. So a shaqiq is your full brother. A shaqiqatu is a full sister. Or you can also say them al-aini, al-haqiqi. So al-akhul haqiqi is the full brother. Al-ukhtul haqiqiya is the full sister. Then you have al-akhul aini wal-ukhtul ainiya. Half brother and sister from the father's side. Al-akhul aini wal-ukhtul ainiya. In English, we call them agnate brothers or agnate sisters. So agnate is the term used if you share the same father, but they're different mothers. And if you share the same mother and you share different fathers, then the term used is uterine. And we need to differentiate between the two because the ahkam of both agnate siblings and of uterine siblings are different. So when we talk about brothers inherit, it can be both full and half brothers, whether agnate or uterine. But when nephews inherit it, then it either is a full nephew or an agnate nephew. A son of your uterine brother will not be inheriting. And by nephew, we mean the nephew of your brother. The nephew of your from your sister's side is not part of the initial respondents to inheritance. Number seven, you have a paternal uncle, whether full or agnate. A full paternal uncle basically uh, your father's mother and father are the same as your uncle's mother and father. So that's a full paternal uncle. And an agnate paternal uncle is in which your paternal grandfather, is the same for your father and your uncle, but your grandmother is not the mother of your uncle. It's some other woman. The uncle's son, so this paternal uncle, whether full or agnate, his son is also on the list. The husband is on the list of heirs, and a freed slave is on the list of heirs. So 10 men can actually become heirs in a given situation. Not all at once, and they have their conditions that will be discussed later. And as far as women are concerned, you have daughter, granddaughter, and so on. Remember, by granddaughter, we only mean the son's daughter, not the daughter's daughter. And by so on, we mean great granddaughter, great great granddaughter, etc. You have grandmother as high as they go. Notice we haven't mentioned the word paternal. This basically tells us that both paternal and maternal grandmothers and great grandmothers and great great grandmothers and so on, they're entitled to mirath. Sister, full or half, whether agnate or uterine, they are inheritors. The wife is inherits, and a freed slave girl. She can also become one of the waratha. So six category of women can possibly become heirs to a person in specific situations. And with this, we come to the end of today's class. If you guys have any questions, I would be happy to take them now.